Good afternoon, this is Sean Golding with Golding & Golding, here to discuss the basics of what happens when you receive a CP3219 Notice of Deficiency. What do you do? How do you respond? There are a couple of different types of 3219 notices, but essentially what it means is that there is a deficiency in tax and the IRS is coming after you. And so it's basically your opportunity to file for tax court, to file a petition. It can be tax liability. It could be an unpaid penalty. It could be interest, a number of different things. At the end of the day, there's an amount due. It was assessed. It wasn't paid. The IRS sent you notices previously, and now you've got what's called a 90 or 150-day letter, a NOD letter, Notice of Deficiency. 90 days if you're in the United States, 150 days if you live outside of the United States. Some important facts about the 3219 notice is that it must be filed with the tax court within 90 days or 150 if you're outside of the U.S. It's a very strict statutory deadline. Essentially what that means is you have 90, instead of going back and forth 90, 150, I'm just going to go with 90, but if you live outside of the U.S., you get 150 days. If you miss that 90-day statutory deadline, that's essentially the end of the opportunity to go to tax court. So once that 90 days expires, you no longer have the ability to file the petition. I mean, you can always try and throw a Hail Mary or two or three, but for the most part, they're pretty strict with it. If you have a $50,000 case or less, then it qualifies for what's called simplified procedures. If not, then you go the regular route. A couple of benefits of going to tax court as opposed to going to Court of Federal Claims or District Court is that you don't have to pay the amount first, which is great, right? You know, if the IRS says you owe $500,000 in taxes or penalties and you're like, well, that's not right, and you're going back and forth, you get to go to tax court where they only focus on tax matters and you don't have to deal with the headache of paying it first. The detriment is that there's no jury of your peers, it's just a judge. But if you lose in tax court, you can still appeal to the Federal Court of Appeals, depending on what circuit you're in. So generally, up front, the opportunity is to go to tax court, federal court, court of claims, which is also federal court. For the two ladders, you have to go ahead and pay first, normally. Okay. A couple of things to keep in mind. If for any reason you miss the opportunity or you don't want to go to tax court, you would prefer instead to go to federal court, you can do so. District court or court of claims, to be more accurate. But you typically have to pay it first. Okay. You have to pay it first and then try to do a claim for refund at the IRS. There's various administrative headaches and levels you have to go through, but you pay it first. You request a refund. When that's denied, you go ahead and you sue for refund in federal court, unless the IRS turn around or the U.S. government and they sue you in federal court. That's basically it for 3219 notices. At my firm here, we deal exclusively in international offshore compliance, expatriation, things like that. So if you're out of compliance, you want to get into compliance, there's various programs you can use to do so. There's the voluntary disclosure program if you're willful or you just can't certify under penalty of perjury that you're non-willful, like if you knowingly failed to file tax returns, let's say. There's reasonable cause delinquency procedures and the streamlined procedures if you're non-willful. We have lots of free information available on our main website and our sub-websites. You can always reach out, schedule a reduced fee initial consultation if you think it's appropriate, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.